recognize a lot of you here, but some of you are new faces, and so if you haven't met me before, I practice in the area of juvenile law. I've practiced for 17 years in the area of criminal juvenile law, and so this year's case is near and dear to my heart. Anytime you talk about crimes, I get super excited. I'm a defense attorney, and so our cases normally rest on cross-examination. We don't always have a lot of witnesses that we get to present, and so to make or break our case, you have to be pretty good at cross-examination. I think it's probably one of the hardest things involved in a trial, because what's the purpose of direct examination? What'd you learn? Get the story out there. And so direct examination is going to flow because you want it to come out in the witness's words, right? You want their story and their words. Cross-examination comes out, and whose words do you want then? Your words. That's exactly right. So we don't want the witness to go on and on and on. We want our words to be out there, and our words, the jury, to hear them. So cross-examination. Boy, how do you prepare for something like that, right? Because direct examination, you have all that time to talk to the witness, to prepare. You guys are going to go over the questions that you're going to ask. You're going to have an idea of what they're going to say. And so it's very easy. It's a give and take. You know exactly where you're going, what question's going to come next. Well, do you get to prepare with the other side's witnesses ahead of time? No. Sometimes you get to talk to them. Sometimes they'll say, no, thank you. I don't want to talk to you before trial. And then you're stuck. So how do you prepare for that? Any idea? What you want to get out of them? How are you going to know what you want to get out of them? Okay. Go. Okay. I'm sorry, I couldn't hear you.
Write down, I was going off what you said with the, right, what they said in their direct examination so you can repair or minimize the damage.
That's exactly right. I don't know which one of you raised your hand first. Just someone say something. So that sounds pretty easy, right? You're going to anticipate what they're going to say, and then you're going to ask something. Well, anticipation. This is something that is really hard for a lot of attorneys. I work in an office with several other attorneys, and there are people who just see things black and white. They look at police reports, and they only see it from their angle. And in their mind, their case is completely solid, and they're ready to go. Well, I personally think that that's a weakness, because if you can't see the case from both directions, you're not going to be able to see what's about to hit you when you get in that courtroom. And so when I first started practicing, I would read the report as if I were the prosecutor. I would look at the police report, and I'd go, what are the good things about my case? What do I want to get out there? And I'd make myself a list of those things. And I did a lot of car cases, a lot of possession stolen car cases, a lot where the person I represented was a passenger in the car. And so I'd start reading that police report, and I'd look for things, and I would say, how old was the car? How old was the person driving the car? What time of day was it? Was there a key in the ignition? Was the column popped? Was there glass on the floor? All these kind of questions that I'm looking for in the police report. And you may say, why do you care about that stuff? Because if I'm the prosecutor, I want to get that out there because the law says you know or should have known that the car was stolen. So as I'm making those lists, then I go back and I read it from my perspective. Now I'm the defense attorney. So what am I going to do with what I just learned about what the prosecution was going to say? So then I start coming up with questions about, well, if it was 10 o'clock at night, it must have been dark. So when I got the police officer on the stand, I would say things like, officer, isn't it true that it was 10 o'clock when you pulled the car over? Yes. Isn't it true that the dome light inside the car wasn't working? Well, yeah. And isn't it further true that my client was actually sitting in the back seat? Yeah. And it wasn't a split seat, right? It was a bench seat? Yes. That was back in the day. It was a long time ago. So it's so you have no idea whether the person in the back seat could even see the ignition of the car, do you? No. Officer, were you in the car when that car was started? No. So you don't know whether or not my client was in the car when the car was started either, do you? No. So you don't know if he was aware that that car was started with a screwdriver, are you? No. And so you've gone through the whole thing, and I anticipated what he was going to say because I had looked at it from the other perspective, and I knew what I needed to minimize. So leading questions. I know you touched on this a little bit. I hear this all the time when we go to trial sites. People will make this objection, it's leading, and they'll get overruled. And they'll say things like, well, but Your Honor, they just answered yes. It was a leading question. Is a yes or no question a leading question? No? Give me an example of when it's not leading. Come on. Yeah, back here. Okay, but what about if you ask a question that the person answers yes or no? Okay, here. Okay, did you fight with him? And why is that not leading?
Because you're not leading the witness to answer whether or not you did have it.
Exactly. And I go to a lot of these, you'll see me at a bunch of these trial sites, and people will continue to say, well, Your Honor, that's leading because they answered yes or no. It's when you suggest the answer that makes it leading. Now, on cross-examination, the only kind of question, the only question you want to ask on cross-examination is a leading question. And I see this mistake a lot, and I made this mistake a lot when I was a new attorney, and it cost me some trials, people. Bad. So when you are asking questions, you don't want to ask the other side's witness, what do you think about my client? Because what do you think they're going to say? Now, you know that they hate them, right? I mean, you've got the history here. You know these people don't get along. You know they've actually been in a fight together. Some words were exchanged. These people just hate each other. Do you think the other side's witness is going to, from the stand, go, I cannot stand him and I hope he burns? No, they're not going to say that, right? So if you say to them, what do you think about my client? Well, first of all, don't ever say the word client. I keep saying it because I don't know the person's name. So let's say Mr. Smith. What do you think about Mr. Smith? They're going to say things like, I've just never had a really, hard feelings toward him. I've tried to be friends with him, but he's just always so mean to me. And not just me. He kicks little dogs. I've seen him push old ladies over. He's horrible. And the jury's looking at him and like, oh my gosh, I hate Mr. Smith too. That's awful. And before you know it, this person on the stand is a victim of their own kind, right? And the jury just wants to believe everything they say because your client is just an awful monster. So when you get up there, you don't ask, what do you think of my client? You ask things like, you know Mr. Smith for a long time, haven't you? Well, yes. You guys don't get along very much, do you? Well, kind of. Well, really? You guys had a fight last year, didn't you? Yeah. Isn't it true you actually came to blows during that fight? Yeah. And you actually said the words, I'm going to get even. Remember that? Oh, I didn't really mean it. Did you say the words? Yeah, I said it. Okay. And a little bit later, you said something like, you will pay for this. Remember that? Yeah, I was just angry at the time, but yeah. Don't let him explain it away. You said it, though, correct? Yes, you said it. Now, today you're here to testify against Mr. Smith in another matter, aren't you? Yes. And you have the ability today to present information that you're going to ask the jury to believe. Isn't that correct? Yes. And at the end of the day, you're going to ask that jury to make him pay, aren't you? Oh, ooh. That's the zinger. That's when you're coming back and you're like, oh my gosh, I just got him right where I wanted him. And now the jury's looking at your witness and they're going, hey, wait a minute. This person might not be so nice. They may be seeing things in a different light because they want to see them in a different light. You don't want to ever go, you're just a liar. That doesn't turn out real well when you try to make the jury go, oh, they're lying. You want to make them seem confused. Maybe they have good intentions, but their judgment's clouded a little bit by this history that they have with Mr. Smith. Things like that. But you always want to end with a good punch, right? You're building up to it. And it may take several questions to get there, but you want to end with something good because you want the jury to remember that last line when you sit down, right? And the other side is going to get up and they're going to try to minimize it the best they can on redirect. But man, if you deliver it right, they're still going to remember that. And they'll go back and they'll be like, I don't know. So then you have to say, well, one of the things I've noticed, let me just say this. One of the things I've noticed about people doing cross-examination, you've got this in your mind, you've got your zinger, you're ready, you're going to build up to it, you just can't wait. It's like jumping rope. You're like, put me in, shut up, just sit down, I want to get to my side, right? And so the whole time you're thinking about how amazing you're going to be on cross-examination, and you're not listening to what's being said because you think you know what's going to be said, and then all of a sudden that witness gets up there and they give you gold. And you're like, did they just say, oh my gosh, they just said something that is going to be amazing for me. And so you start writing it down real fast. Oh my gosh, I got to get to that. I got to get to that. And, as Julie said, sometimes on direct, you want to end with that really good statement. If you can anticipate what that good statement's going to be and the first thing out of your mouth is something that refutes that, Oh, my gosh, that's amazing. I love that. I do that all the time on closing. The DA will get up and they'll say something, and I just pop up and I'm going, actually, Your Honor, and then I'll say something to go with it, and I'll be like, but we'll get back to that in just a minute, and then I'll go on to what I plan to say, right? And it sticks with the judge because you don't want them having that just sitting there and brewing in their mind. You want to be like, that was a silly statement. Let's all get that out of our heads and let's just go on. And then you've got their attention again, right? Yeah. So listen to your witnesses and take note of what's going on. Don't get so caught up in what you've prepared that you lose the biggest gift you've ever been given. I had a trial last year. Got to tell you a little war story here. Had a trial last year, and man, I was ready because I thought, it's going to be tough. It's going to be a tough one, but I think I can win it. And I felt really justified in my case, but I knew there were some weaknesses. I never, for the world, I never thought that the person was going to go and stand and actually say that they weren't sure. And so the DA has their client up there, or their, not client, but their witness up there, and they're giving their side of it, and I'm like, and then the DA goes, and do you see that person in the courtroom today? And she's like, I think so. And I thought, what? What did she just say? You think so? And everything I prepared, all those questions I thought I was going to have to really rely on, just weren't as important anymore. Because what was so important? Identification. If you don't have the right person in the courtroom, the rest of this is all just for nothing. And sometimes it's just that simple. Doesn't matter how much you have prepared, you may not need it. Don't go overkill. You present exactly what you need to know, and you let it go. And if that means you ask 5 questions, but they are the best 5 questions that you've got, great. Sometimes less is more. And I see people who do that. They ask one too many questions. You had it, and then all of a sudden you lost it. And watch your jury, watch your judge. You will see when you've lost them. And when you've lost them, you might as well just stop talking, because it doesn't matter what you say at that point. And sometimes they'll get angry at you. When they're done, they're done. And if you keep talking, they're going to hold it against you. And then they'll just be like, yeah. I've seen that on my judge's face before. In the middle of a trial, I've thought, I'm not even going to put my witness on because we're winning right now. And if I put some other people on and drag this out, she's going to be mad. And so I'll lean over to my client. I'll be like, I think we should just rest at the end of this. We've got her. And they'll be like, okay. And that usually works out. If you know your people well enough, if you're good at watching body language, do that. And if you're not good at those things, you have a few weeks before the competition starts, learn it, okay? So, yes. Sometimes it's about pacing. And, you may have just been like monotone, going and going and going. And so just take a break. It may be the difference in the sound of your voice. It may be that you drop it down a little bit. And then all of a sudden, you're talking quietly. And then when you want to make your point, your voice gets up and they look up and they're like, hey, they're still talking, okay? So it's just little things like that. Watch your jury, see what works. I don't mean just stop your case and walk off, but do something that gets their attention again. And it's about time for me to wrap this thing up, or it is time for me to wrap this thing up. So any question real quick before I leave? Good job, guys. Thank you.